Straight ahead on Law and Crime Daily. The defense scores a win in the Florida prosecution of NFL owner Robert Kraft.
What they never did is hit the stop button on the recorder.
A constitutional violation shuts down a sex crimes case.
Plus, Louisville, Kentucky prepares for a decision on possible criminal charges in the shooting death of Breonna Taylor. Her family calls for justice.
It is on Daniel Cameron and the Attorney General of Kentucky's office.
And chaos in the courtroom is caught on camera, adding extra time to a defendant's sentence. Law and Crime Daily covers court cases from coast to coast.
And welcome, everybody, to Law and Crime Daily. I'm Aaron Keller, along with Brian Buckmeyer and Terry Austin. The defense for the owner of the New England Patriots scores a legal touchdown as prosecutors in Florida refuse to press forward with a case against Robert Kraft, who was charged in connection with a sting operation at a Florida massage parlor where authorities say some patrons were paying for sex acts. The police installed and monitored hidden surveillance cameras inside private areas of the spa. But the process of how the police built their case was fraught with errors, and both trial judges and appeals judges agreed the evidence gathered should be thrown out of court. Let's look back at testimony from a pretrial suppression hearing which exposed the legal problems with the case.
If we had something that was illegal, it was going to be obvious.
You're looking into the prying eyes of a detective who watched a video feed of customers inside a Florida massage parlor. Some were said to be paying for sex, others were not.
She came in, and fairly quickly I realized that this was probably going to be a legitimate massage based on her demeanor.
Defense attorneys for Robert Kraft convinced a Florida judge that the police operation was unconstitutional.
I think they said, which I have no reason to dispute, they were trying to maintain the dignity and respect and concern for the dignity and respect of these people. The fact is, that's not what the Constitution requires in any part of this country.
The search warrant which authorized the sting did not require police to minimize their intrusion into each patron's privacy, and police did little to minimize intrusion on their own.
The instructions on minimization have to be put in the affidavit and or the warrant. It has to be very clear and set out and explain what it is you do to prevent innocent people or innocent conduct from being captured.
The judge said detectives here simply saw and recorded too much. The spa advertised services for women clients, and in fact, more than one woman had a significant portion of her spa time viewed by a detective, and the entirety of her spa time recorded and placed in Jupiter Police Department records. Failing to consider and include instructions on minimizing the impact on women is a serious flaw in the search warrant. The judge's order went on to criticize the viewing and recording of the legitimate massages of male clients as well. Prosecutors unsuccessfully tried to convince the judge that they did minimize their intrusion.
Officers want as much evidence as they can get. They called us on the phone. They told us what we had. We said, shut it down. Because 4.5 days was plenty.
The judge suppressed the recording and the subsequent traffic stop, which identified Kraft.
And ultimately, the trial judge and the appeals court ruled the evidence was unconstitutionally gathered and had to be suppressed. Terry Austin explains the arguments from both sides at the appeals court level. Terry?
The arguments deal actually, Aaron, with the Fourth Amendment, which requires a judge who issues a warrant to specifically name what officers can seize. The legal issue is whether the judge who signed the original warrant told the police to use techniques to minimize law enforcement intrusion into the privacy of legitimate spa customers. Here's how the state attempted to argue that the operation was constitutional.
There simply was no Fourth Amendment violation here, either as a matter of the warrant clause, because these warrants contained everything that the Constitution requires, or as a matter of the reasonableness clause, because given what police knew at the time and given the circumstances confronting them and the difficulties of this unique kind of search, their conduct was lawful. Second, even if you find that there was some police misconduct, the remedy could not possibly be the extreme remedy of total suppression that these defendants urge on you. And that's because of the good faith exception, because of ordinary Fourth Amendment standing principles, and because of the limited nature of suppression that applies in a case of this nature. But the defendants' arguments in Kraft and Zhang turn on 4 or 5 federal court of appeals decisions, which of course were not binding on the lower court and are not binding on this court. And some of those decisions suggest that the text of the warrant clause requires what courts have called talismanic minimization language in the scope of the warrant itself, in the plain text of the warrant itself. But that's not correct. And in fact, there is a dispute amongst even federal judges about whether or not the warrant clause imposes that additional requirement that is not anywhere within the text of the warrant.
Defense attorneys for Robert Kraft say the prosecutor told the officers to, quote, record everything. The defense argued that was unconstitutional.
So the state tries to say, look, we did minimize. We engaged in extrinsic minimization. We only monitored for 30 days. But what they never did is hit the stop button on the recorder. They recorded for 60 straight days. The U.S. Supreme Court has made it clear that the purpose of the exclusionary rule is to deter police misconduct. So in this case, when you have intentional disregard of the minimization requirement, they would serve the purpose of deterring future police misconduct to ensure that law enforcement does not in the future blatantly disregard the minimization requirements that apply to video surveillance.
A rather shocking moment in the courtroom during the suppression hearing last year when Kraft's attorney asked a cop who pulled him over about statements captured on his body-worn camera during the operation. For that side of this story, we turn to Brian Buckmeyer.
The defense accused an officer of making up a reason to pull over some of the defendants suspected of paying for sex acts at the spa where the sting took place. Now, the officer was grilled when they took to the stand about a radio transmission regarding another defendant. In court, it looked like another point for the defense, but later, prosecutors accused the defense of mischaracterizing the radio transmission. Here's the defense line of questioning during a pretrial hearing.
I'm asking you, do you recall saying it doesn't matter in response to that? I can make some up.
You said this, that I said that during the Robert Kraft traffic?
No.
Right, this traffic stop right before that. The traffic stop right before that when your audio was on, before you ever knew you were going to stop, Mr. Kraft.
Okay. I truly, I'm sorry, I don't remember saying that.
Okay.
And I don't, I would, if I said it, I wouldn't even know the context of how it was said, and obviously, and more of a joke with however you heard that.
Okay. So
that was said.
Okay. So you, whether it was a joke or not, you don't have
I don't have a recollection of it, so I'm not going to tell you that who I was talking to or whatever. I have zero recollection that I said that.
Okay, Brian, so the cop was trying to basically explain that he had to find another reason to pull over suspects, such as maybe failing to stop at a stop sign, something like that, some pretextual reason. Here, that's how they were identifying the people they caught on the video in the spot. Do you have some constitutional issues with this?
Exactly. Like what the defense is doing here is trying to pigeonhole the officer to say, why did you stop him? Obviously, there is a paper trail and probably prior depositions. And what you're seeing here is that officer floundering because they know that something is incorrect. This is not going to pass constitutional muster. And that's why this case, or at least part of the reason why this case, ended the way that it did.
So, Terry, the defense in the appeal accused the cops of basically flatly lying in their search warrant application by citing a case on minimization, this whole legal concept of minimization, which the cops then admitted on the stand that they never actually read. So, Terry, how is it that the cops are submitting applications saying, we're going to use this case, and then they say we never read the case?
Well, that's a problem, Aaron. You know, the officers should know the techniques involved with minimizing the intrusion to the other customers and invading their privacy. And if they say they knew and they understood, and they're citing a case which outlines how you should be doing the minimalization, and it turns out they didn't actually read those cases, then they're lying, and that is a big problem.
Brian, your reaction to this quickly. Prosecutors are refusing another layer of appeal here, so the case is all but formally dropped. Prosecutors are saying they don't want to risk stacking up higher level precedent against future cases. Your reaction?
I mean, that's smart because even myself here in New York, I'm thinking, how can I get that case law to apply to my clients here in Brooklyn? And they understand that every defense attorney in their county, in their state, is salivating at that ruling because it's going to help a lot of people who don't have Kraft's money.
You want this precedent all over the country. Well, still ahead on Law and Crime Daily, crazy courtroom moments and explosive drama. But first, Louisville, Kentucky, bracing for a decision on whether to bring criminal charges in the shooting death of Breonna Taylor. That's when we return on Law and Crime Daily. Plywood boards on windows and concrete barriers now lining the streets of Louisville, Kentucky, as the city braces for possible backlash to a possible announcement by the state attorney general in the police shooting death of Breonna Taylor. Taylor was killed in her home when officers executed a no-knock warrant. Those officers are now under internal investigation and may also be the subjects of a secret grand jury probe into what went wrong. Among the officers are Sergeant Jonathan Mattingly, who was shot during the raid but who has since recovered. Detective Miles Cosgrove was placed on administrative leave along with Mattingly. Former officer Brett Hadkinson was fired for blindly shooting 10 rounds into Taylor's apartment. Taylor's family was awarded a record $12 million civil settlement in a wrongful death suit against the city. But an attorney for her family said recently that justice cannot end there.
We still are demanding that Kentucky Attorney General Daniel Cameron bring charges immediately against the police officers that murdered Breonna Taylor. Justice delayed is justice denied. And at the very minimum, second-degree manslaughter charges. Because we want full justice for Breonna Taylor, not just partial justice.
As part of the settlement, the city and police agreed to make several reforms, including how search warrants are conducted. But as part of that settlement, the city did not have to admit fault.
Currently in our process, a search warrant is applied for by the officer. It is reviewed by potentially a commanding officer in many cases, but not necessarily always. In the instant it is signed off by a commanding officer, that may be by somebody in an acting capacity. What this agreement does is solidify that it will be an actual commanding officer of the rank of sergeant or above.
This agreement or settlement agreement does not say that there was any wrongdoing done. In this case, it's just an acknowledgement of the need for reform and the need for a settlement to take place.
Brian and Terry back again for analysis. So, Brian, all of these preparations, this is going to be a monumental announcement. Either way it goes down.
Yeah, and to be honest, I'm too jaded to believe they're going to come with an indictment. I believe an indictment should be here. I believe that manslaughter in the second degree or reckless homicide should be there. But they're giving too much. The $12 million, the new law reform, the boarding up of the wall as a preparation. It makes me think that someone knows, and I don't want to add a conspiracy theory out there, but it makes me feel that we're not going to get the indictment that people are thinking is going to come down.
Terry, should charges come in this case? Your thoughts?
You know, I think there should be some action against the police officers. I do think there should be some charges. You know, they were reckless in firing, 10 rounds into the house, not knowing exactly who was in or who they may be hitting. So the civil settlement is well and good, but I do think that in order to change the actions of the police, we need to take action against the police.
Yeah, there needs to be some individual accountability here. And Brian, you're shaking your head. Terry, you're agreeing with me. Something just doesn't sit right with this whole concept that there's a warrant secured on sketchy grounds, Brian, because they're looking for drugs. Where were the drugs?
Exactly.
I mean, exactly.
There's a lot wrong with here from the inauguration of the warrant to how it was filled out. It's all wrong.
We need some more transparency in this case. I want to see exactly what's going on. How did they secure the warrant? I want to see more paperwork. And this one, Terry.
No, I agree with you. We need to see more paperwork and we need to see charges filed against the police officers.
We will wait and see if that announcement comes this week. There's no telling if and when it indeed is going to come. And still ahead here on Law and Crime Daily, watch as a Florida sheriff tries to explain the strange conduct of one of his own deputies now facing charges. And we go inside some of the nation's courtrooms as proceedings turn to chaos. Cameras in courthouses capture a lot of things, verdicts, arguments of law, and sometimes they capture mayhem. Here's such a moment brought to us by Court Cam, a Law and Crime series which airs on the A&E network. Here is Dan Abrams.
We go to the Veterans Memorial Courthouse in Lansing, Michigan, for the trial of 35-year-old Joshua Harding, who's been charged with 2 counts of sexual assault. There's Harding. 2 prosecutors represent the state. including Jonathan Roth, who, prior to sentencing, asked the court to consider a sentence on the higher end of the guidelines. At the far end of the table is Detective Brian Kanan, the lead investigator in the case against Harding. The jury's reached a decision in one of the cases and is about to read its verdict. In under 8 seconds, so much has happened. Let's look at it again. If you look a little closer, you can see Harding remove something from inside his sleeve. Turns out Harding is holding a metal shank. Harding storms the prosecutor's table, headed straight for Assistant DA Roth. If not for the quick reflexes of Detective Kanan, Roth could have sustained serious injuries. 2 court deputies immediately take action to help bring Harding, who stands 6'6" and weighs 280, to the ground. Watch as Roth removes his glasses to take a step towards the scrum. A spectator points something out to Roth. It's the shank. Meanwhile, Kanan and the 2 bailiffs are still wrestling with Harding. It took about 30 seconds to eventually cuff and remove the defendant from the courtroom. This brazen attack brought Harding an additional charge of assault with intent to murder, to which he pled guilty. As for the original charges, Harding was found guilty of second-degree criminal sexual conduct and is now serving a combined sentence of 44 years at a state prison. The earliest he could be released is the year 2064. Authorities are unsure how Harding got the weapon into the courthouse. Because Harding was in police custody during the trial, he did not have to pass through a metal detector upon entering the courthouse. He also was not required to wear handcuffs.
And when we come back, the mother of a slain Georgia man says others are exploiting her son's death. The Jacksonville, Florida Sheriff's Office arresting one of their own officers in a bizarre case said to involve bribery. Officer Brian Pace resigned from the force after his superiors say they caught him trying to solicit a female crime victim for inappropriate photographs. The victim, a woman, had her cell phone stolen. She merely wanted it back. But when Pace allegedly asked her for the illegal trade for photos, she filed a complaint. Here's the undersheriff describing what happened.
He answered a call for police service back at the beginning of May, where he had contact with a female victim who had misplaced or had some property stolen. He took a report basically over the phone, and then he reinitiated contact with her shortly thereafter, claiming to have her property and that he would give her property back if she would send him some inappropriate photographs via the phone. A long conversation between the two. Integrity Special Investigations got involved, conducted an investigation. The last piece of the investigation led to a culmination last night where he asked to actually meet the victim, claiming he was going to give her property. And when he pulled up, he was arrested shortly thereafter. So he was arrested for the felony. He resigned from his position with the agency, as I always try to tell you, ladies and gentlemen, that he will not then be employed. There will not be this long process of why is he still working for the Jacksonville Sheriff's Office. He elected to resign from his position, therefore he will not have the civil service protections, and we have to go through that long ordeal.
And that was a courageous complaint. And finally now to a dispute involving the memory of Ahmaud Arbery, gunned down on a nearby road after looking at a house being built in Georgia. CNN is reporting that Arbery's childhood friends have filed a trademark registration for the phrase, "I run with Maud." The application was filed May 9th, less than 2 days after arrest warrants were issued for defendants Gregory and Travis McMichael. CNN says Arbery's mother is complaining that the friends who are attempting to register the trademark are trying to profit from Arbery's death. The friends say they're trying to preserve the mark since one of their team members uttered it, and to preserve it for Arbery's mother and father. Back now with Brian and Terry. So Terry, there's a bit of an estate battle between the mother and the father of Ahmaud Arbery here. The friends say that both parents would benefit from this rather than just the mother said to be benefiting from the GoFundMe without the father. But the big question is should this mark be given federal trademark protection?
Well, yeah, I think it should be, but the question is whether or not it should be given to the friend who's registering it or to the Ahmaud Arbery family, because technically a trademark or a service mark, it's a word that is protected and it identifies the source of the goods. And I think the family could argue here, the source of the goods is Ahmaud Arbery himself. The source is his name, and they could easily argue that someone is trying to take advantage of his name. So I do think they have a good argument. I do think they and their lawyers should jump on top of this and register the mark themselves.
You could always contest the registration. And again, trademark law is primarily for consumer protection. When you buy something, you want to know where it's coming from. Brian, your thoughts on this? Should the friends get the mark or should it go to the family?
Yeah. So Terry is definitely the expert on this, but I'll try to dip my toe into this. Unless there's some sort of contractual agreement prior to making that trademark, I think it's going to be a very long and drawn-out legal battle for the family, and I'm not sure they'll actually come out on top at the end of the day. It's going to be difficult.
It's another case for us to watch here on Law and Crime Daily. Good analysis, and thank you for joining us. We'll see you next time as we discuss justice in America.
I'm Dan Abrams, and this is the Law and Crime Network. The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage. Watch the Law and Crime Network today.